Senate File 1835 is a bill that focuses on the welfare eligibility residency requirements, and if passed would change the waiting period from 30 days to 60 days for people moving to Minnesota and applying for welfare assistance. Everyone has a constitutional right to travel, and we want to encourage people to come to Minnesota looking for work. This bill encourages people to find a job if they want to come to Minnesota. The state of Minnesota has an interest in people working in Minnesota. The latest statistics that I have on your desk, gathered by the Revisor's Office, they came in February, but the statistics are 2010, show that 25% of MFIP cases, Minnesota Family Investment Program cases, were open for people moving to Minnesota. 25%. That's a growing number, members. The prior year numbers were 19%, a little over 19%. In addition, 30.2% for DWP, displaced workers, and 13.1% for general assistance. These numbers are substantially higher than the estimates that DHS gave during testimony, but DHS did not contest my figures, but said it may also include people moving to Minnesota from other countries as well as other states. Attempts to change the waiting periods to 6 months or longer have been rejected by various courts across the country, but courts in Wisconsin have upheld Wisconsin's language for a 60-day waiting period.
Senator Gazelka, I hope you'll pay attention to this, because I think you made a comment relative to the question and answer with Senator Latz that understands that maybe there might be a challenge or maybe there might be some court litigation. No, not maybe. There absolutely will be litigation. And if I would disagree with Senator Latz in any part of his remarks, it would be that it's very clear when you read the Sands case that this is not an issue that's going to be resolved by the Minnesota Supreme Court or by a trial court in Ramsey County. This is Supreme Court, U.S. Supreme Court dictum. And in the same way that the Supreme Court has not overturned Plessy v. Ferguson or Brown versus Board of Education, I mean, pick any of the cases, this was a case decided, as Senator Latz pointed out, in 1999, I believe on a 7-2 vote. It is established law. To change this and change the established legal dictum in regard to durational residency for these benefits, you would have to go to the U.S. Supreme Court to do so.
Thank you, Mr. President. I think there's a strong temptation on the part of lawyers in this body occasionally to revert to their legal arguments. But what we have is a bill that includes public policy. And so I'm sure that a bill like this, if passed and signed, will get litigated, but I don't think we should do it here on the Senate floor. And there may be good legal reasons to vote no. Senator Cohen and Senator Latz, very good lawyers. But I think there are some good public policy reasons to consider Senator Gazelka's bill. And I think from a public policy point of view, it makes sense to say that if we are going to ask Minnesota taxpayers to provide benefits, then we should try and make sure that it's Minnesotans that we're benefiting.
So I want to strike down this issue of Minnesota being a welfare magnet, because that's kind of what we always hear in this issue. And I'm not saying that because Senator Gazelka has said that today, but I'm saying that that's the underlying premise of this. Now, when you put benefits together, including the SNAP program and maybe others, there could be some a benefit to someone that goes there that signs up for each and everything. But the premise that people that come to Minnesota to get cash assistance on the Minnesota Family Investment Program get more than the surrounding states is wrong. So I don't see a reason for this. I don't see where there is a problem. I don't see what there is an issue. At any time, members, we can get somebody that tells us that they think that somebody is potentially doing wrong. But we have not gotten any indication from the evidence that suggests that this is an issue.
This bill is focused on the state's interest of people coming to Minnesota looking for work. And I'm not an attorney, but I think I do understand common sense. And if we have a growing number of MFIP cases and GA cases, or medical assistance cases, that we have an issue that we need to take a look at. And certainly 25% of new cases being paid out to people moving here is something I think we need to pause at. We know that 30 days is, quote, constitutional, but we don't know that 60 days is not also constitutional. Nowhere that I could see has 60 days ever been rejected by the courts. Nowhere that I can see.